If you have an H-1B visa, if you are waiting on one, if your entire career, your family, your future in the United States is tied to this one piece of paper, stop everything you are doing and watch this right now. Because in the last few weeks, something has happened in Washington that could change the trajectory of hundreds of thousands of lives. First, the Trump administration slapped a $100,000 fee on every single new H-1B petition. $100,000, not $2,000, not $5,000, $100,000. And now a group of 8 Republican lawmakers just introduced a brand new bill called the End H-1B Visa Abuse Act of 2026 that would freeze the entire H-1B program completely for 3 years. And when it comes back, it would barely be recognizable. 3 years of 0 new H-1B visas. This is not a rumor. This is not speculation. This is happening right now, and today at Global Entry News, we are going to break down every single detail you need to know. Welcome to Global Entry News, your most trusted source for breaking immigration news, visa updates, and the stories that impact real people building real lives in the United States. If you are watching for the first time, please subscribe right now and hit that notification bell because what is happening with the H-1B program is moving fast, and if you are not staying current, you are already behind. We are here every single time there is a major update, and today is one of the biggest ones we have covered in a long time. Today, we are covering 2 explosive developments that together represent the most aggressive crackdown on the H-1B visa program in the history of this country. First, we are going to walk through exactly what President Trump's $100,000 fee proclamation means, who it hits, who it does not hit, and what it has already done to the program. Second, we are going to break down the brand new End H-1B Visa Abuse Act of 2026, introduced just days ago on April 22nd by Congressman Eli Crane of Arizona and co-sponsored by 7 other Republican lawmakers. We will tell you what is in this bill, what it would do if it passes, and what every H-1B holder and applicant needs to understand right now. Let us get into it. Let us start from the beginning, because to understand where we are today, you need to understand what happened on September 19th, 2025. That was the day President Donald Trump signed a presidential proclamation titled Restriction on Entry of Certain Non-Immigrant Workers. It was a Friday. And by the time most people woke up the following Sunday, the H-1B world had been turned completely upside down. September 19th, 2025, Trump signs presidential proclamation imposing a $100,000 fee on all new H-1B petitions. Effective date, September 21st, 2025, 12:01 a.m. Eastern Time. The proclamation was simple and brutal in its impact. Starting at 12:01 a.m. on September 21st, 2025, any employer who wanted to file a new H-1B petition for a worker currently outside the United States would be required to pay $100,000 per petition, not as a bond, not refundable. $100,000 paid upfront per application. To put that number in context, before this proclamation, the standard filing fees for an H-1B petition ranged from roughly $2,000 to $5,000, depending on the size of the company. The Trump administration just made it 20 to 50 times more expensive overnight. The White House's justification for this move was direct and pointed. The administration argued that the H-1B program had been, in their words, deliberately exploited by companies. They cited statistics showing that some of the largest H-1B sponsors in the country had simultaneously been conducting major layoffs of American workers. One company was approved for over 5,000 H-1B workers in fiscal year 2025, while laying off approximately 16,000 American employees that same year. Another company received approval for nearly 1,700 H-1B workers, while announcing the elimination of 2,400 American jobs in Oregon. A third company reduced its American workforce by 27,000 people since 2022, while receiving more than 25,000 H-1B approvals during the same period. The administration's position was unambiguous. These companies were using the program to replace American workers with cheaper foreign labor, and the $100,000 fee was designed to make that calculation far less attractive. Now, there are important details about who this fee does and does not apply to, and these details matter enormously for people currently in the H-1B system. The $100,000 fee applies only to new petitions filed after September 21, 2025, for workers who are currently outside the United States. It does not apply to H-1B renewals or extensions. It does not apply to workers already inside the United States changing employers. It does not revoke any previously approved H-1B visa. And it does not prevent current H-1B holders from traveling in and out of the country. So if you already have H-1B status and you are in the United States, this proclamation does not directly affect your current visa. But if you are outside the country and hoping to get a new H-1B petition filed on your behalf, your potential employer is now looking at a $100,000 price tag just to get started. Impact already visible. By February 15, 2026, USCIS had received only 85 payments under the new fee. External H-1B applications dropped 87%. USCIS lost approximately $19.5 million in fee revenue. The numbers tell the story clearly. By February 15, 2026, less than 5 months after the fee went into effect, USCIS had received just 85 payments under the new $100,000 requirement. External H-1B applications had dropped by 87%. The program that once processed hundreds of thousands of applications annually had essentially been reduced to a tiny fraction of its former volume. The fee had done exactly what it was designed to do in terms of reducing participation. But economists and technology sector leaders were already sounding alarms about what that meant for American competitiveness, innovation, and the broader economy. The legal status of this proclamation has also been contested from the very beginning. Senior legal experts in immigration law raised serious questions about whether the executive branch has any constitutional authority to impose a fee of this nature without congressional authorization. Aaron Reichlin-Melnick, a senior legal fellow at the American Immigration Council, stated publicly that the president has, in his words, literally zero legal authority to impose a $100,000 fee on visas. The argument is that Congress has only ever authorized the executive branch to charge fees to recover the cost of processing an application, not to impose financial deterrence of this magnitude. Legal challenges were filed, and those battles are still working their way through the courts. But before those legal battles are resolved, a group of Republican lawmakers decided to take things further, much further. On April 22, 2026, Congressman Eli Crane of Arizona introduced the End H-1B Visa Abuse Act of 2026. And the name tells you exactly where this legislation is going. April 22, 2026, Rep. Eli Crane, RAZ, introduces End H-1B Visa Abuse Act of 2026, co-sponsored by 7 Republican lawmakers, proposes complete 3-year freeze on all new H-1B visas. This bill, co-sponsored by 7 other Republican representatives, including Brian Babin, Brandon Gill, Wesley Hunt, and Keith Self from Texas, Andy Ogles from Tennessee, and Paul Gosar from Arizona, proposes the most sweeping restriction on the H-1B program that has ever been introduced in Congress. Let us go through exactly what this bill would do, because the details are staggering. First, and most immediately, the bill calls for a complete 3-year pause on the issuance of any new H-1B visas. 3 full years, no new approvals, no new entries into the program. The program simply stops. After those 3 years, it would restart, but under rules so fundamentally different that the program that comes back would be almost unrecognizable compared to what exists today. When the program resumes after the 3-year pause, the annual cap would be cut from 65,000 visas to just 25,000. That is a reduction of more than 60%. The current lottery-based selection system would be eliminated entirely, replaced with a wage-weighted selection model where higher-paying jobs get priority. The minimum salary required to qualify for an H-1B visa would be set at $200,000 per year. The program currently has no such blanket minimum. Employers are only required to pay the prevailing wage for the occupation in the area. But under this bill, $200,000 annually would become the floor, period, regardless of location or occupation type. Beyond the cap and salary changes, the bill goes even further. It would ban third-party staffing companies from sponsoring H-1B workers altogether, which would effectively eliminate the outsourcing model that many large IT staffing firms have built their entire business around. It would end the optional practical training program known as OPT, which currently allows international students who graduate from American universities to work in the United States for 1 to 3 years before needing to transition to another visa status. Ending OPT would close off the pipeline from American universities to American workplaces for hundreds of thousands of international students. And, in perhaps the most consequential restriction of all, the bill would prohibit H-1B visa holders from adjusting their status to permanent residency, meaning even if you come to the United States on an H-1B, you would no longer be allowed to use that as a path toward a green card. Come work here temporarily, the bill effectively says, and then leave. The population that would be most severely affected by this legislation is Indian professionals. Over 70% of H-1B visa holders are Indian citizens. Combined with Chinese nationals, the two groups account for more than 80% of the entire program. If this bill becomes law in any form close to what has been proposed, the impact on Indian and Chinese professionals in technology, healthcare, engineering, and research fields would be catastrophic and immediate. It is important to be honest about where this bill stands in the legislative process, because understanding the difference between a bill being introduced and a bill becoming law matters enormously. As of today, the End H-1B Visa Abuse Act of 2026 has been introduced in the House of Representatives. It has not passed committee. It has not been voted on by the full House. It has not been sent to the Senate. Immigration lawyers and policy analysts across the spectrum agree that in its current form, this bill faces enormous opposition from universities, hospitals, technology companies, major business associations, and even some members of the Republican Party who represent states with large technology sectors. The $100,000 fee proclamation alone has already gutted external H-1B participation. A full 3-year freeze would deliver a blow to American innovation and competitiveness that many economists say the country simply cannot absorb. But here's what matters right now. Even if this bill does not pass in its current form, its introduction signals something critically important. The direction of travel in Washington on H-1B is unmistakably toward restriction. The $100,000 fee, the wage-weighted lottery, Project Firewall, the Department of Labor's new initiative targeting employers who violate H-1B wage and compliance requirements. The state-level actions in Texas and Florida banning new H-1B hires at public universities, and now a congressional bill proposing a complete 3-year shutdown. These are not random events. They are a coordinated, escalating push to fundamentally transform or eliminate the H-1B program as it has existed for decades. Here is what you need to take away from everything we have covered today. The H-1B visa program is under the most intense pressure it has faced in its entire history. The $100,000 fee is already in effect and has already reduced new external applications by 87%. A new bill introduced just days ago proposes a complete 3-year freeze, followed by a dramatically smaller, more expensive, and more restrictive version of the program. And the political momentum in Washington is clearly moving toward further tightening, not toward relief. If you currently hold an H-1B visa and you are inside the United States, the most important thing you can do right now is to understand your renewal timeline and make sure you are not caught off guard by any future changes. If you have any pathway to a green card, through your employer, through a family member, through any other avenue, you need to be actively working on that right now and not waiting for the legislative picture to become clearer. The picture may never be clearer than it is today, and waiting has real consequences. If you are currently outside the United States waiting for an H-1B petition to be filed on your behalf, you need to have an honest conversation with your employer about whether the $100,000 fee changes their willingness to sponsor you, and you need to be exploring alternative visa pathways in parallel. The L1, the TN for Canadian and Mexican professionals, the O1 for individuals with extraordinary ability. There are other routes, and now is the time to understand them. And if you are an international student currently in the United States on an F1 visa counting on OPT as your bridge to an H-1B, you need to be watching the progress of this legislation very closely, because the pathway you are counting on is directly in the crosshairs of this bill. At Global Entry News, we will be here every step of the way. We will follow the End H-1B Visa Abuse Act of 2026 through every stage of the legislative process. We will cover every court ruling on the $100,000 fee. We will report every major development that affects your ability to live, work, and build a future in the United States. That is our commitment to this community, and we are not going anywhere. If this video gave you information you needed, please share it right now with everyone in your network who is connected to the H-1B program. Colleagues, friends, family members, anyone whose career or life could be impacted by what is happening. The more people in our community who are informed, the better prepared we all are. Subscribe to Global Entry News if you have not already, turn on your notifications, and we will see you in the very next update. Stay informed, stay prepared, and stay with us.